Hello everyone and welcome to another video of Know the Law. So the 2020 election cycle is almost over and we are about to see what direction the American voters want to take the country in terms of political legislation and outcomes. Now, one issue that I do not believe is going to disappear immediately following the general election is regarding the Supreme Court, specifically in the number of justices that we should be serving a lifetime appointment on the highest court in the land. Now, for those of us who follow political news, the issue of whether or not Congress should be moving forward with filling a Supreme Court vacancy during a presidential election year has already been answered. It's done. The answer is that it ultimately depends on the political agenda of the majority party controlling the Senate at the time of the vacancy. And for the Republican Party, they have certainly solidified this precedent for the foreseeable future. If you agree, if you disagree, comment below and we'll discuss the conversation and continue the conversation in the comments section. But moving past this particular issue, there's a new conversation about an older idea that has reemerged during this election cycle, and it is the idea of court packing. Now, there are many on the Democratic side that want to see a Biden presidency win the election in order to increase the number of justices on the Supreme Court, especially in response to the confirmation of Justice Amy Coney Barrett. Court packing is not something that just emerged in the 2020 election cycle. It's something that's been around for many years and many decades, and even almost since the beginning of our nation. In fact, many students of political history could make the argument that both parties attempted to pack the court at every chance they get. I mean, this is something that happens in politics. You take political action that favors your political agenda. And since it is an election year, we see the Republicans trying to change the conversation and shape court packing and define it with a negative connotation, claiming that this is a very bad idea. Well, yes, it kind of is, but that depends on your perspective. It certainly doesn't help the Republican Party and their political agenda, and that's why they view it as a bad idea. But if it was such a bad thing, why did the Republican Party initiate this precedent? So what do I mean by that? Well, Senator Ted Cruz, the junior senator from Texas, likes to brag about being from the party of Abraham Lincoln, who founded the Republican Party as we know it. And yet, it's kind of ironic that it was President Abraham Lincoln who initiated the precedent of court packing by increasing the Supreme Court to 10 justices. That's right, 10. So in July 2013, Professor Timothy Huebner, who was an editor for the Journal of Supreme Court History, ended up partnering with the SCOTUS blog to write an article about this important event in the court's history. Now, in the article titled "The First Court Packing Plan," Professor Huebner describes how the U.S. Congress originally had 6 justices serving on the court. And as the country expanded, so did the circuit and the Supreme Courts. Now, Professor Huebner writes, at that time, the justices were serving both double duty as a member of the federal circuit judges and fulfilling their duty on the Supreme Court. They had to endure hardships of early 19th century travel, where they spent most of their time, in fact, the majority of their time, traveling on the circuit and away from the nation's capital. So it made sense during the 1800s, during the time of President Lincoln, to expand the courts. And since the founding fathers of the Constitution did not specify a specific number of justices to serve on the court, they gave Congress the flexibility to adjust the court's size. And I guess we can make the argument that that's the originalist argument of how to view this topic in terms of the Constitution. Now, why would they allow this to happen? Well, they gave the legislative branch the power to make sure that the courts did not become a branch of government that was completely disconnected from the public will. So Professor Huebner stated that when the Civil War came, the Supreme Court became the center of a controversy. And to offer a little bit of a recap about what was going on at that time, in 1857, the Supreme Court issued the infamous Dred Scott decision, which was in favor of permitting slavery. Now, this, of course, led to President Lincoln being elected in 1860, who made a name for himself by being a vocal opponent of slavery. There was a rapid succession of court vacancies that followed the Dred Scott case, and it gave President Lincoln the golden opportunity to reshape the court. Now, one thing to note was that Lincoln was not trying to appease the southern states when making a nomination to the court. In fact, Lincoln did the exact opposite. He sought to appoint justices that would further the federal aim of preserving the Union and ending slavery. This is someone who is acting on a partisan agenda, albeit for a noble cause. Now, at the same time, Professor Huebner wrote that there were like-minded Republicans in Congress seeking to redraw the boundaries of the federal circuits. Now, why would the Republicans want to do that? Well, in the summer of 1862, Congress squeezed all the justices from the southern slaveholding states into two circuits, and they were previously in five circuits spread across, but they eventually shrunk it down to two. This was done in order to legitimize the appointment of northern justices and reduce the influence of the southern states on the court. In essence, it was court packing done by the Republican Congress. Now, a year later, in March 1863, the Republican Congress went further, and they created an additional circuit and thus an additional seat on the Supreme Court. Remember, the two were connected. A Supreme Court justice was also serving in a circuit court. The move to create a 10th Circuit was both pragmatic and political, but ultimately the addition of another justice would certainly aid Lincoln and the Republicans in prosecuting the war. And by adding a justice, the Republican Congress reminded the court at a critical time that it had the power to affect its membership. Now, I'll pause and just put as a side note, the Congress could have instituted a constitutional amendment at that time regarding Supreme Court vacancies and how many seats they would permit, but they chose not to. And we'll come back to that later in the video. But Republican efforts to adjust the court to accommodate political realities did not end there. In fact, we see it changed over the decade. So in 1866, 3 years after the Act of 1863, the Civil War has ended, Congress, which was controlled by the Republicans, enacted legislation reducing the court size to 7 justices. It went from 10 justices and reduced it down by 3 to 7 justices. And they did this because they wanted to prevent President Andrew Johnson, who was a fierce opponent of congressional reconstruction plans. They wanted to prevent President Andrew Johnson from nominating any justices. Republicans were concerned that by allowing the court to remain at 10 justices, that President Johnson would ultimately appoint justices that hindered the healing of our nation following the Civil War, and they wanted to at least try to minimize the damage. Again, albeit a noble cause. But 3 years later, in 1869, when President Andrew Johnson was out of office, the Republican Congress once again returned the size of the court to 9 justices, and it's remained at 9 ever since. Now, regardless of how pure the intentions a party may have been at the time to implement court packing, there are plenty of historical precedents to show that has happened, especially by the Republican Party. Between 1862 and 1869, Congress rearranged the federal courts and the circuits to curb Southern and Confederate influence, and they added a 10th justice to uphold Union war policies and reduce the size of the court to thwart the antagonistic president, being Andrew Johnson. Taken together, these measures constituted a mostly partisan attempt to reshape and structure the personnel of the Supreme Court, which we can say definitively was the first court packing plan. So now moving past this history recap, let's take a quick look at how this conversation could unfold in the new legislative session that's going to begin this upcoming January. So currently we have Republicans wanting to lead the public conversation and claim that court packing should be stopped at all costs. They incorporate phrases in their conversations and their televised debates and say the radical left agenda has to be stopped at all costs. And they use it as a scare tactic to rally up their base. But they have their own far right agenda that many Americans do not agree with. And just in the past couple of weeks, what we've noticed is that Senator Ted Cruz has introduced two different pieces of legislation aimed at keeping the Republicans in control of the courts for generations to come. Remember, this is Senator Ted Cruz, who claims to be a Republican of Abe Lincoln's party. So what we're noticing here is that there's a shift in the Republican Party of their mindset from the past to current. For clarification purposes, let's look at some of the legislation that Senator Ted Cruz has introduced. So the first one that we want to look at here is S 8505, which is titled "To Create a Point of Order Against Legislation Modifying the Number of Justices of the Supreme Court of the United States." Now, for clarification purposes, a point of order is a parliamentarian procedure that is used when discussing business on the floor. The text for this piece of legislation has not been officially published yet, which should be within relatively soon, and we'll keep a lookout on congress.gov for the official text. But based on what we can read in the title of the bill, it seems that Senator Cruz is targeting any attempt to introduce legislation that would increase or potentially decrease the number of justices on the Supreme Court. Yes, court packing usually refers to expanding the court, but it can also refer to um, decreasing the court as well. But Senator Ted Cruz did not stop there. He also introduced a joint resolution, a Senate joint resolution, and it's targeting the same thing that we discussed previously. And this one goes a little bit further. And it's a resolution proposing an amendment to the Constitution of the United States to require that the Supreme Court of the United States be composed of 9 justices. Okay, so let's look at this a little bit further. If we look at the details section of the bill, the resolution, we can see that it has 13 co-sponsors, and all the co-sponsors are Republicans. They're not Democrats. And even if you look at the other bill, it has 13 sponsors, co-sponsors, and again, they're all Republicans. So this is not a bipartisan effort. We're having Republicans try to limit court packing, even though they're just as guilty of using court packing in the past. Again, albeit for noble purposes. But there's a position statement that came out from Senator Rob Portman from Ohio. And on October 21st, 2020, he issued the following statement, and I'll read it verbatim. Packing the Supreme Court with more justices simply to try and dictate preferred policy outcomes is dangerous, and I hope Congress avoids going down this path. Well, let's pause for a second. Sure, that most people can agree with that. You don't want to politicize the court. But Republicans have already done that. Republicans did that when Abe Lincoln was president. They specifically packed the court for a preferred policy outcome, which was to end slavery and be pro-union and not allow the Southern Confederate states to have influence in the direction of the nation. I don't know how else to describe what they were doing. There's no other term to describe it other than court packing. So Senator Portman continued his statement saying, the structure of our judicial system should not be a political issue. If Congress increases the number of justices each time power changes hands, the court will lose legitimacy and credibility. This common sense proposal will ensure we keep the same number of Supreme Court justices we've had since 1869 and removes the structure of the court as a political issue. Well, the court's always going to be a political issue until the senators no longer confirm Supreme Court justices, then it's always going to be a political issue because the senators themselves are politicians. So that's not going to change, and that's just a moot point here. But it's not like the court is changing every single time we change presidents or even change the majority in the Senate. This is the first time we're actually having this conversation since the 1940s. So it's just a conversation. And that's what a healthy democracy does. They have conversations and they disagree. But to enact legislation immediately in response to shut down the argument is a little premature, at least from my perspective. So I have some important questions that I just want to conclude this video on. And I'll begin with asking, why didn't Abraham Lincoln and the Republicans think back in 1863 to do this, to institute a constitutional amendment to limit the Supreme Court justices on this, and the number? Why didn't the founding founders and the framers add an amendment to the Constitution to limit the number of justices on the Supreme Court? The founding fathers and the Republicans at that time it could be argued by many people that they did not want the judicial branch of government to become totally disconnected from the public will. And what we're witnessing from the Republican Party today is a modern twist on the original court packing blueprint that was done by President Lincoln and the Republicans in Congress at that time. While we will definitely wait for the text for the proposed constitutional amendment to be published by Congress.gov, it is safe to infer that that Senator Cruz is attempting to secure Republican efforts to pack the Supreme Court politically with only conservative justices. And that's not what a healthy democracy does. They're trying to take a risk and say, if we can have a constitutional amendment to have only 9 justices, then that can limit the focus for the Republican Party to always maintain control of the Senate every time there's not a Republican president in office. And therefore, they're going to try to make every effort to always have a conservative court as a majority, if not in its entirety. So this is something that's we're going to see a little bit more more developments within the conversation as we head into the new legislative session, especially if the Republicans maintain control of the Senate, and if especially if Donald Trump is reelected for a second term, we can see them definitely moving this legislation forward, and we'll see what happens with the Democrats and how they combat it. So thank you for taking the time to look at this this type of issue a little bit more closely with me. Feel free to leave your comments and feedback below, and hit the subscribe and like button if you enjoyed the video. So until next time, YouTube, be well.